Welcome viewers to the PI Show. This is the show that talks about everything to do with personal injury law and litigation. I'm John Karantzis, and tonight I have two experts in workers' compensation. Toby Robinson, hello.
Hi John, good evening viewers.
And Dean Hadjina.
Good evening, John. Good evening, viewers.
Tonight, viewers, we have an update on workers' compensation law and litigation. However...
Before we get to that, John, what's in the news?
Okay, Toby, well, what's in the news is a teacher has been awarded $220,000 in regards to an IKEA chair. What happened here?
Well, John, it's been reported in the news that a teacher went to sit on a fairly inexpensive IKEA chair, and my understanding from reading the article is the chair collapsed and she suffered a significant injury to her knee.
Dean?
Oh, well, I initially looked at this and thought that it must be a fault by the manufacturer or perhaps IKEA, but it goes on to say that I think the school or the council actually constructed the chair and
Yes.
it fell apart as the teacher sat on it. I think it actually says that it's a manufacturing fault where the chair is slippery on polished surfaces. So
Okay. And this is a Martin chair by IKEA, a $30 Martin chair. Now, once it's manufactured and put together, and it was assembled by the council, so that's why the claim is against the council, Dean.
yeah, and I think an engineer did say that these chairs had a structural fault.
There was no claim against IKEA?
Well, not according to this.
No.
Which
Strange.
is interesting, yeah.
But she suffered injury and, well, $220,000 later. It's a great settlement, isn't it?
Well, yeah, certainly it's a very big figure.
And this is in Perth, wasn't it, Dean?
Yes, in Western Australia.
So she suffered significant injuries, Toby.
That's right, John, and because of this chair, the article says that the council who assembled the chair had issues with it before,
Yeah.
collapsing on these slippery surfaces. So
It just goes to show that sitting on a simple chair and which collapses, causing injury, well, viewers, you do have a claim.
exactly.
Yeah,
And especially if it's not your fault.
yeah. And I think one of the keys is that the council was on notice. They knew that this had happened previously.
Okay.
But obviously it was a costs
Okay. Well,
benefit analysis.
people are now on notice.
Yeah.
Anyway, guards smoked out. What's happened here, Dean?
Yes, John, this relates to a prison ban where prisoners are no longer allowed to smoke. It's led to riots, but it's also led to prisoners making their own tobacco, which is sort of probably open up another avenue of, currency in the prison system.
And you've got a scenario now where, because of the rioting involved, the prison guards, the wardens, they've all suffered psychological claims, haven't they, Toby?
They have, John. Obviously, these riots were extraordinarily stressful for the prison guards, and the article makes the point that a lot of them haven't been able to return to work and are having real difficulties with stress.
So they're entitled to medical-like expenses compensation, weekly payments compensation, and most likely lump sum compensation.
That's potentially right, John. If they put in a work cover claim and they have an injury as a result of the stressful situation they were put in, they're the benefits they could be looking to access.
Now, they are working in a environment whereby injuries are sort of known to occur, aren't they? It's a prison.
It's a prison, it's a stressful environment,
Yeah.
and this is a situation where it obviously got out of hand and there was a significant riot.
The interesting question, Toby, isn't it that tobacco is a legal product, but it's banned in this prison and in all correctional facilities in Victoria?
That's right, John. I think this was an initiative of the previous government, and it's led to big troubles in the prison system. I'm not sure what's happening now.
No.
This was a major riot.
Yeah, it was a major riot. So, and a lot of prisoners were charged. But anyway, it just goes to show viewers that the institutions have responsibilities over their employees. Now, they were aware that there was going to be a lot of problems by banning tobacco.
Some of the issues, was that the Naffine government introduced this policy, the Labor Party came into power, and then there's talk about whether or not it's been introduced correctly. So maybe rush through
Anyway,
without thought to the workers.
What's
there.
occurred is there are employees have been injured and now they're entitled to workers' compensation
absolutely.
benefits. But we'll go on. And then we've got this other heading, charges for AMBO assaults. Toby, what's happened here?
Well, this is a case of alleged assault of an ambulance officer.
Which we've spoken about repeatedly, haven't we, on this show, about how ambulance officers, firefighters are getting attacked in the course of their duties. It's shocking.
It is shocking, John, and just going off the media reports, it seems to be on the rise, which is very concerning. These are people out there, doing a good service for the community and just being attacked and targeted. Very concerning.
Now, again, these employees, as in nurses, doctors, firefighters, they've all got entitlements to compensation for weekly payments, lump sum benefits, because of the failure to protect their job security.
That's right, and unfortunately, because there's significant injuries, they could be significant claims.
Yeah, well, it's like we've changed the police. They've had two people, walking around the streets together, driving together. Ambulance officers probably need the same protection, because here you've got a 30-year-old and two teenagers alleged attacked an ambulance worker. Doesn't say whether this person was on his own or not, but perhaps something else that needs to be considered in terms of, better guidance, especially because they're on notice. It's happened a couple of times now. It's started to become a bit of a trend.
And that's the key. The employer is on notice about these attacks. And we've also got the scenario where police are lodging work cover claims because of the weight of the belts.
Yeah.
And again, Toby, that's a pretty good claim, isn't it?
It can be, John. These are just things that, as you say, I think the employers have to be aware of.
Oh, yes. Especially if complaints are made about the defect or about the weight, for example, of the belt causing lower back injury and nothing's done about it by the employer.
Yeah, that's right.
Finally, we have an inquest going on in Sydney about the Lindt Cafe. One of the survivors, Ms. McHale, has quoted to say that you've left us to die. What's that about, Dean?
Well, this is actually the manager, I believe, of the cafe, and she was on the phone, I understand, with police during the hostage situation, and she at the time was saying they weren't doing enough.
Yes.
Basically warning the police that, he's made these demands, and she's been told on the phone, or the message has been relayed to her that we're not going to adhere to this. So the stress level for her would have been horrible, I suppose.
So there's an issue about what the role of the police negotiators was at the time of the incident.
Yeah.
And their conduct.
Yeah. And
which will be dealt with by the inquest.
Yeah. It's also questionable what support or training. I mean, I know it's a unique situation, but she obviously was left on her own.
And that's how she felt.
And
yes.
she probably had to filter the messages that she was sending to the actual
well, Dean, we'll find out.
Yeah.
We'll wait to see what the inquest determines. Thank you, viewers. We'll be right back after this short break with a work cover update. Welcome back, viewers, to the show. Tonight we have a work cover update. We'll examine 4 leading and current work cover cases. The first case, the Box Hill Institute of TAFE and Johnson, 2015 Victorian Supreme Court Court of Appeal case. Toby, what happened here?
Well, John, this was an appeal slightly unusual because it was an appeal by both parties, but it was an appeal of a damages decision for both a physical back injury and a mental injury claim.
Yes.
In that decision,
So, Mr. Johnson,
Mr.
he's a worker at the Box Hill Institute of TAFE, wasn't he?
He was, John. He was a teacher there, and he suffered an injury to his back at work, and he also suffered a mental injury in the course of his work.
Now, the back injury was pretty straightforward, wasn't it?
That was fairly straightforward, and he was awarded a sum of damages for the back injury, and neither party seemed to have an issue about that. That wasn't what the appeal was about.
Dean, he was awarded $125,000 for the back injury. From my recollection, he was lifting engines in the automotive department of the Box Hill TAFE.
As a teacher. Yeah.
As a teacher, and there were various aggravations, and he claimed in negligence that the TAFE did not provide him with a safe workplace or a safe system of work. So he was successful in this instance in the Court of Appeal before his Honour Judge Forrest. However, the psychological injury claim is pivotal here, isn't it?
Well, in relate, the worker alleges 12 separate incidents, and they particularly relate to an employee, I think his manager, Mr. Williams.
Yes.
For example, one of the incidents that the worker alleges is that Mr. Williams had asked him if he'd get his work completed before the Easter break.
Yes.
And he alleges that was a form of harassment and bullying.
That in itself.
Well, that's one of several incidents he alleges, yes.
So what the court requires is each instance of bullying and victimisation to be particularised.
Yeah.
In this instance, Mr. Johnson, via his lawyers, have particularised 12 instances, didn't they?
Yes.
Now, these instances, what did the judge determine in relation to 11 of these 12, Dean?
Well, 11 of them weren't successful in that, for starters, they didn't actually constitute putting the employer on notice. They didn't actually constitute bullying. The judge actually found that the worker was a poor historian, couldn't remember certain things, but then what he could remember, he'd remember well. So there was issues about credibility. The 12th and final incident, funnily enough, there's a witness that supports his claim, and that in itself got him a successful verdict on that one issue.
So the court found that he was vindicated on the 12th incident that he alleges caused him psychological injury. What was that 12th incident, Toby?
That was an incident at a meeting, John, where the supervisor that the plaintiff in
Mr.
this
Williams.
case, the worker, Mr. Williams, alleged had bullied and harassed him.
Well, for apparently 10 minutes, he had, in an open room in front of his colleagues, had really gone to town on his work ethic.
Aggressively criticised him.
To the point where Mr. Johnson was crying uncontrollably in his lap, correct?
That's right. He broke down in tears, and the judge at first instance was able to establish this happened the way it was described because there was a witness.
And after this incident, he did not return to work again.
That's my understanding.
And that is pretty crucial, isn't it, Dean?
Oh, it certainly is. It probably identifies it being as a more significant incident than the other incident.
It was the straw that broke the camel's back. And that's, I think, the judge's wording.
Yeah.
Oh, I think that's right, John. And that was enough to get him a successful award of damages.
Yeah, I think the judge then was able to use that final incident by then saying that the employer was on notice that there was issues. There was a relationship problem with his manager. There was alleged bullying going on. So they were on notice on other incidents, even if they on their own weren't.
And that's crucial, isn't it?
Oh, certainly
As in the employer, as in the Box Hill TAFE, being on notice, being aware that this argy-bargy is going on and kept on going on for quite a while.
Yeah, and that's
they didn't do anything about it.
No, and the legal term obviously is, foreseeability. Is the employer on notice? Can they, from what they've been told and what they know, is it possible or is it reasonable to expect that something else will occur if they don't interfere.
So the grounds here, and viewers, this is in any psychological claim for lump sum damages compensation. Causation has to be established, as in the conduct has to be pretty serious enough to cause psychological injury.
Yeah.
Now, out of all the grounds apart from one, the judge found that yes, that's occurred. And then secondly, it's critical, isn't it, Dean, that the employer is on notice
Absolutely.
about what's going on.
On notice, and it's interesting that that last incident, there's a witness. Obviously,
That confirmed
yeah,
Mr. Johnson's story.
yeah, very important.
Now, viewers, there were many times where, and we see this all the time, as in new clients come to see us and say, look, we're suffering this form of, stress and anxiety at work. And then we ask, so what have you done about it? What have you said to your employer or your supervisor? And they say nothing.
Yes.
That should not occur, should it?
No. I think it's probably a natural instinct when someone's bullying you to go into a shell, but at least
You
consult. You've got to get some support. Speak to the employer. It may have to be a different level of management. But
Exactly.
you've got to speak out.
You need to speak out, viewers. You need to complain. Well, actually, not even complain. It's just say, well, look, what's happening to me by this conduct, and this conduct is causing me severe injury.
It is affecting my mental health.
Yes. And if you complain and the employer still does nothing about it, then you're in a good position, aren't you, Dean?
Oh, absolutely. I mean, an employer may very well change things for the better, but if not,
Otherwise,
you know,
the
to
employer has the defence,
That's
don't
right.
they? The
Yeah.
Kohler defence,
Yeah, that's-
a famous case in legal land whereby the defence is the employer did not know anything about it. How were we supposed to do something about it?
yeah,
And Toby, that defence arises quite often, doesn't it?
It does in these sort of cases, and as you've said, John, that's why the worker has to establish that the employer was on notice.
And viewers, we're going to a short break now. However, after the break, Toby will tell us about a case whereby the worker failed in his psychological claim because foreseeability was an issue. Welcome back, viewers, to the work cover update in regards to, in this instance, a few psychological damages claims. Toby, matter of Gregory Johnson and Berry Street, Victoria. What happened here?
John, this was a claim for damages for a psychological injury. The worker alleged that his employer had was negligent in causing his mental injury. The facts of the case were that he was a social worker for a charitable organisation called Berry Street.
Yes.
He was working with a young man, and who I believe there was a possibility this young man had been sexually assaulted himself.
Yes.
And in doing so, it seems that for the worker in this case, whose name was also Johnson, this brought back memories of sexual abuse he'd suffered in his life.
Yes.
And caused him a mental injury. The key issue in the case, though, was the employer at fault for this injury? Could it have been prevented by something the employer did? And were they on notice about the issues he was suffering as a result of his work with this young man?
Now, this all arose when the person he was caring for said to him that I was sexually abused when I was young and you looked like the guy that did it.
That's
Now-
right.
Now, when this was said to Mr. Johnson, well, his world came apart, didn't it?
yeah, it brought back memories. Mr. Johnson says that it affected his ability to continue working, that he basically asked to be removed from the care of that individual.
He felt like he couldn't work
Yeah.
anymore with this individual. And this is where the factual matrix becomes very important, because his supervisor, Ms. Bell, gave evidence at court whereby, and the court found she was a fantastic witness, Toby. She was very understanding, and the court was of the view that, sure, Mr. Johnson had told her various issues, but it was not made clear to Miss Bell that he had to stop work immediately.
Yeah.
And if anything, that was not good for him to stop work.
No, I think he actually did keep working.
He kept working, and
There was a further incident that occurred when Mr. Johnson was not at work. I think they had a workers' day or something. They had pizza and things like that. So the workers were all meeting at work. He's in the car park and this other individual is there. He's surprised to see him, confronts him as to why aren't you caring for me anymore. The worker says this brought back memories, made things worse. Through his lawyers, alleged that the employer did not provide a safe workplace. He shouldn't have been in the vicinity of the same person on that day. But then it gets a bit more problematic because the court has to find that the employer was in fact on notice at this stage, and I don't think at this point of this incident that it actually was the case.
so Mr. Johnson's basically, he's alleged that the employer, when they became aware of how he was feeling, should have stopped him from working.
That's right, John. That was the argument put at court, but the defendant raised a few issues with that. Firstly, it seemed like the major cause of his injury was simply being confronted with this young man and his memories of being sexually abused coming back. Now, what could the defendant really have done about that?
No, there's no foreseeability there.
No foreseeability there. And secondly, the worker sought to argue at court that he should have sort of been stood down as soon as these difficulties became apparent. But unfortunately,
And that's the issue. When did they become apparent?
when did they become apparent? In a sense, his version of events was, I think, not quite as compelling as the supervisor's. And ultimately, the court found that I think that Berry Street had been reasonably sympathetic and had tried to intervene when these issues started, when they became aware of the issues.
Viewers, this is a classic example of testimony in open court and how people give this type of evidence. The plaintiff was not viewed as favourably as the witness, the supervisor, Ms. Bell. Her clear recollections of the events in question impressed the court, didn't they, Dean?
Yeah, well, example was the worker saying that the employer was on notice that he was struggling with his work. Well, there's no evidence to suggest that.
No.
In fact, to the contrary, Mrs. Bell actually gave evidence that they weren't aware, and as soon as they became aware of issues, that's when they took action. So if in fact he was having issues, or if anyone's having issues, they should make it clear what it is and what the consequences might be, so that action can be taken. There's no point bringing it up 6 months later to try and go back in time. You've got to put them on notice straight away.
Unfortunately, Mr. Johnson in this case failed in his proceeding, Toby. There's an award of costs against him. Viewers, we all have to be mindful that in employment, there's always going to be psychological issues arising, issues of bullying, issues of victimisation. Of course, our old friend Oscar Yildiz at Bully Zero, he's always there to help. And viewers, if anyone's suffering this type of problem, they should contact Bully Zero to get their assistance. And also, HR advisors, they should also contact Bully Zero to find out where they stand in these type of scenarios and situations. Toby, Griffin and the Victorian Work Cover Authority, 2016 Victorian Court of Appeal decision. What happened here?
So this is a different type of case, John. This is a case about a worker who suffered a physical injury.
Yes.
he'd been doing some construction work on a apartment building, I believe. And as with a number of construction activities, there are a number of different parties involved.
There are.
And this was a case about once the injured worker, Mr. Griffin, had suffered a back injury, who was responsible and how should the court apportion liability?
So the claim is against the employer.
So we've got an employer involved and we've got a head constructor
Yes.
who has overall charge of the site.
Of the site,
and
yes.
the building. And then we've got subcontractors as well involved.
Yes.
And the court has to determine, look into who's responsible and to what extent.
What happened in the end, Dean?
Well, the court ended up splitting liability amongst the three defendants.
They found them all guilty in negligence.
Yes, and that's, I guess, it's importance of pleading the case properly, because just because there's 1 to 3 defendants, each case is different depending on the facts. The court looks at the contracts, what was agreed to between the parties, who was responsible for what.
And the employer was held 25% responsible.
Yes.
The head contractor 50% responsible because they had overall control of the site. And the third respondent, the contractor, the scaffolding contractor, another 25%. Viewers, that's all time we have for tonight. Thank you, gentlemen. Dean,
Thank you,
Toby.
Thank you, John.
Viewers, any work cover issues, any work injuries, please contact us at Nwiki Carbone. We are the experts. I'm an accredited specialist in personal injury law. We are here to help. We'll see you next time. Thank you.